field. I am very pleased that they've been longtime associates of myself as well as the college. And with that, I'm going to turn the session over to Garrett and give us a second to change over the slides here. Okay, Garrett, that should be you. So Garrett, are you on mute?
I was on mute.
Okay.
So thank you for the reminder. So good morning, everyone. I am an attorney, a partner at Kollman and Saucier. We are a management side, labor and employment law firm. We have represented the college for a number of years, and we specialize in all sorts of labor and employment matters, really runs the gamut. And so that's what we do. And in the last month, 6 weeks, we've become immersed in the FFCRA, which is going to be the primary subject of this webinar, as well as what other workplace concerns we need to keep in mind during these unusual times. And Eric's going to briefly introduce himself as well.
Hi, thank you, Garrett. Thanks, Janet, for the introduction. As Garrett said, and as Janet said, we are attorneys who've done employment law for our whole careers. I've known Janet since she was working at Ryland Homes a lifetime ago for both of us when I had a full head of dark hair. And we've continued to work together over the years in a variety of capacities. So I'm going to let Garrett do the bulk of the talking. He's really our firm's expert in these coronavirus related issues. I'm going to cover some stuff on the back end and the Q&A. As you'll probably hear at the end, if we can't get to everything you all ask us today, you are free to reach out to either one of us later on and email us, call us if there's any follow-up issues. So with that, I'll turn it back over to Garrett.
Thanks, Eric. All right, so briefly here, we're going to move rather quick. There is a lot of content to cover in the nearly 53 minutes that we have left. We will get to questions, and if you have follow-up that are not addressed in the next hour, please follow up with us or your counsel to make sure you're handling the situation appropriately. Just very briefly, this presentation and what we're going to say today is not legal advice. What we're talking about and when we're answering questions are hypothetical. This does not create an attorney-client relationship, nor is the subject of our conversation subject to the attorney-client relationship. So there's no privilege. So just bear that in mind, and appreciate your understanding for the legal disclaimer there, given the nature of this presentation. We are going to primarily focus on the Families First Coronavirus Response Act, which is the FFCRA, which has two main provisions: the Emergency Family and Medical Leave Expansion Act, shorthand EFMLA, and Emergency Paid Sick Leave Act, EPSL, which are two new buckets of leave that many employers are now subject to, and we'll explain the obligations, other requirements, and some nuances to the law that you should at least be mindful of. There's also a tax credit component to the FFCRA, which we will identify and explain to you. And then we'll talk about the CARES Act, which was phase 3 from Congress regarding the coronavirus pandemic, which provides loan opportunities and expanded unemployment. And then, as I mentioned, we're going to be covering other employer obligations during this time. The FFCRA went into effect on April 1st, and the United States Department of Labor has said that it would give employers a 30-day grace period from when the law was passed to comply in good faith and figure out how to comply in good faith. Well, that 30-day period expires today. So tomorrow is day one for when the DOL says it's going to start enforcing this law, and the grace period is no longer. But we don't need a grace period. We're all going to comply, and that's why you're on this call today, to make sure you're doing it right and to get your questions answered. Very high level, the EFMLA provisions here, this is 12 weeks of job protected leave. It's an expansion of the traditional FMLA, but it provides a new reason, which I will get into shortly. But it applies to employers who are not covered by the traditional FMLA. So this may be a new content area for many of you on the call. Of those 12 weeks, 2 weeks, the first 2 weeks are unpaid for the EFMLA provisions. However, the following 10 weeks, up to 10 weeks, is paid at 2/3 of the employee's regular rate of pay. And we'll explain to you how to calculate that regular rate and also some of the caps that apply on both a daily and an aggregate basis. The second component of leave here is EPSL, which is up to 80 hours of paid leave at either a full pay rate or 2/3 pay, depending on the reason. And we'll go through the 6 reasons that EPSL is available and the caps that come into play there. All employers, all private employers with fewer than 500 employees are covered. And this is what I was discussing when I said those of you who are not traditionally covered by the FMLA with fewer than 50 employees and a 75-mile radius are now covered by these laws, which are currently in effect until December 31st of this year. The statute says that they sunset. It's anyone's guess whether they'll be extended or further modified, but for now, this law is on the books until the end of 2020. So how do you know how many employees you have? Well, you can account any and every employee you have. That's full-time, part-time, temporary, seasonal, all go into counting whether or not you have fewer than 500 employees and are therefore covered, or 500 or more employees and not covered by the law. These laws have specific definitions for who's full-time and who is part-time. A full-time employee is one who regularly is scheduled to work 40 hours per week, and a part-time employee is everyone else. So someone who regularly works 37 hours per week is not full-time for purposes of this law. It's the 40 hours is the threshold. And what you're going to do there is generally you're going to look back over a 6-month period and determine whether or not the employee is working 40 hours per week on average to determine whether the employee is full-time or part-time. And the reason the distinction matters is there are some nuances in how much leave under the emergency paid sick leave provisions an employee gets. Another thing to bear in mind when we're talking about the employee count is whether you are sufficiently related with other entities such that you should combine the employee count. And there are 2 tests that are used under these laws. I'm not going to get into the minutia on these tests, but just bear in mind if you have an interrelated operation where there's a shared HR function or common management, control of labor relations, those are things that are going to contribute to whether or not you are what is called an integrated employer, and therefore you might have more than 500 employees when counting both Company 1 and Company 2. We also got to keep in mind whether we have a joint employer status with respect to any employees. And if that's the case, we want to make sure that those entities we contract with, if we're using their employees, but we have a sufficiently controlling relationship with them, we're setting wages, we're hiring and firing, we're controlling work schedule, we want to make sure those related entities are doing the right thing and complying with these laws so that we're not held liable for someone else's mistake. So the key point here is keep in mind the relationship you have with other entities, and consult with your legal counsel. Give us a call to determine whether or not there is an impact here that you need to be mindful of. There's a pretty foundational argument or a position here that we all need to keep in mind when we're talking about EFMLA and EPSL. And what that is that the employee, in order to receive leave under either of these buckets, must be unable to work or telework. Janet mentioned that we are in and this is no secret, we're in a different environment with remote work, and everybody's working with their home environment. If somebody can work remotely, they're not going to be eligible for this leave. So that is a foundation here in order for someone to receive the paid leave or unpaid leave benefits under these two laws. There's only one reason that EFMLA is available. If you've looked at guidance on the FFCRA that is a month or more older, I suggest you not use that material and instead look at updated guidance. And the reason is that the law was changed before it was passed by the Senate, between what the Congress initially passed. And so therefore the reasons that the leave is available have been modified. So you want the up-to-date guidance on this from the Department of Labor in order to make sure you're appropriately complying. There are 6 reasons for EPSL. And again, I'm not hiding the ball here, but I will get to each of those reasons. If you're wondering what it means for an employee to be able to telework, this slide sets that out per the DOL regulations. And that an employee can telework when the employer allows the employee to perform work at home or another location other than the normal workplace. So the employer gets to make that decision. It's not, the employee can't decide I can or cannot telework. That's the employer's decision. Speaking specifically to the EFMLA reasons, this is one reason and one reason only, and that's an employee is unable to work or telework because he or she needs to care for a child if the child's school or place of childcare has been closed or is unavailable due to a public health emergency. And so that's this public health emergency, what we're referring to is the COVID-19 public health emergency. At this juncture, we're not talking about any other public health emergency. We're in COVID-19 land. So if an employee cannot work or telework because they have to care for a second grader whose school is closed, they'd be eligible for leave. It's not just children who are under 18, however. It also is available for children who are over 18 if the child has a mental or physical disability, and that disability makes the child incapable of self-care. In order for an employee to be eligible for EFMLA, the employee must be on payroll for at least 30 calendar days. That's not a requirement for the EPSL. This is just EFMLA. Now, there's a lot of economic uncertainty now, and prior to today, particularly in March and April, but also moving forward, companies are considering layoffs, furloughs, reductions in force based on how they're able to weather the pandemic. So if you had an employee on payroll on or after March 1st, for example, and that employee worked for 30 calendar days, that employee is generally going to be entitled to EFMLA if that employee returns to employment. And the key there is just to remember, if you've made some employment decisions, you've sent folks home because of a lack of work or a government order, and then you rehire them, they're not starting anew and counting whether or not they've worked long enough for you to be entitled to the leave. And as I mentioned previously, this is 12 weeks of job protected leave, but it is the same 12-week total cap that applies under the traditional FMLA. And what that means is for those of you who are traditionally covered by the FMLA, this is not a separate 12-week bucket. This runs against the same 12 weeks. So if I had an employee who took 6 weeks of FMLA before all of this happened, that employee would only be eligible for an additional 6 weeks of EFMLA under the 12-month period that you use. And if you use a rolling method, for example, once the employee is eligible for additional time as that 12-month period moves forward, that employee would be eligible for additional leave. And if you're not an employer who's traditionally covered by the FMLA, that may be foggy to you, but those of you who are covered by the FMLA, you'll understand what I'm saying there. And also bear in mind that these are, again, 2 different buckets of leave. EPSL is entirely separate. The first 2 weeks are unpaid. So what is an employee to do to receive income during this 2-week period. They can use accrued leave under your existing policies, or they could use this EPSL bucket, which is the reason 5 under the EPSL, which is the same reason that EFMLA is available, the school closure, child care provider, unavailable reason. But an employee gets to choose. Keep that in mind. You can't make the employee use EPSL. You can't make them use existing leave. They get to choose during that first 2-week period, which is unpaid for purposes of EFML. Then it's the 10 weeks that is paid at 2/3 the employee's regular rate for the hours the employee is normally scheduled to work, at a maximum of $200 a day per employee, or $10,000 total per employee. Or excuse me, that should be an and, really. So it's $200 a day cap, but also a $10,000 total cap per employee. And again, you're going to look back for a 6-month window to determine the employee's regular rate of pay. That includes wages, commissions, tips, piece rates. Those would all go into the calculation to determine how much is the amount of the employee's regular rate of pay. And at no point can the regular rate of pay be less than the applicable minimum wage. I mentioned previously that we're talking about job protected leave. And so generally what that means is that if the employee takes leave, whether it's EFMLA or EPSL, the employee is entitled to their job back when the need for leave expires and they're ready to return to work or telework. That's not a carte blanche they're absolutely entitled to return to work. And there are different criteria that we have to keep in mind here. Oddly, the Congress has made it more onerous for small employers to deny job restoration than it has for employers with 25 to 500 employees. And here's why that is. Not to get too deep into the weeds, but if you're a small employer with fewer than 25 employees, you're not required to restore an employee who's used leave for the school child care reason, only if the position no longer exists due to operational changes resulting from the COVID-19 emergency, you've made reasonable effort to restore the employee to the same or equivalent position, and then for 1 year after that, you make reasonable effort to contact the employee about available equivalent positions. So that's not a requirement. That's not something that an employer with 25 or more employees has to do. There's something under the FMLA called the key employee exception. And so if you have a key employee, which is a salaried employee who is one of the highest, among the highest 10% paid of your workforce, generally, you can designate that employee as a key employee who would not be entitled to job restoration as well. But more broadly, the rules regarding job restoration and employment decisions under the traditional FMLA continue to apply. So what that means is if you're making layoff decisions, reduction in force decisions, furlough decisions, employees who use this leave are still subject to those decisions so long as you're making the decision based on a legitimate business reason. More specifically, that means that if I take EFMLA and then you decide to implement layoffs, so long as that layoff would have occurred even if I had not taken leave, then you can lay me off as well. It does not insulate me from legitimate employment decisions. And that's important given the economic times we're living in, whether or not you've received a PPP loan or other loan, we're all going to be weathering this storm differently. And so bear that in mind. I'm going to transition now to the emergency paid sick leave provisions. This is leave up to 80 hours that is in addition to what you already offer, whether that's universal leave or PTO or vacation, sick leave to comply with the Maryland Healthy Working Families Act. This is a new bucket of leave. And any employee on payroll is eligible for this leave so long as the employee has a qualifying reason. The could be an employee who was on payroll before April 1st, hired on April 1st, hired today, and on day one, the employee is eligible. There's no 30-day waiting period as there is under the EFMLA provisions. I've mentioned before that for full-time employees, they're entitled to up to 80 hours of EPSL. For part-time employees, they're entitled to the number of hours normally worked over a 2-week period. And generally, for all things under these two laws, you're going to look back generally six months to determine the average number of hours worked, the regular rate of pay. An exception here is for employees who have not worked for 6 months, you're going to look over the duration of employment, which makes sense. If you don't have 6 months to look at, you can look at the 4 months that they've been on payroll or 2 months that they've been on payroll. I'm going to, in a slide or two, I'm going to tell you what you do for an employee who works in a regular work schedule. How the heck are you supposed to calculate that? I also want to let you know that there are different caps that apply for leave used under the EPSL. For the first 3 reasons, and I'll show you, we're going to get to the reasons here shortly, but for the first 3 reasons, it's a max of $511 per day and an aggregate cap of $5,110 per employee. For the latter 3 reasons, reasons 4, 5, and 6, reason 5 being the same reason that's available under the EFMLA, an employee is eligible for a maximum of $200 per day or $2,000 total per employee. So bear that in mind. And my recommendation is to use this PowerPoint as a guide once you receive it following the webinar. I think it's a helpful outline if you have an employee that comes to you and you want to know, where do I slot them in? What do I do here? This is a good, you can find which criteria that they're satisfying, know your caps, know the reasons, and know the documentation and notice that you can require. So I hope you'll find the written outline that this PowerPoint is helpful moving forward. If you do have an employee with an irregular work schedule, it's a complicated process. It involves a lot of math. I'm a lawyer, which means I'm very bad at math. So what you're going to do there, you're going to look back over our 6-month period, and you're going to find the average number of hours worked per day. You're going to do some multiplication. It's all spelled out in the DOL regulations. But my advice is, if you have an employee with an irregular schedule, and you're trying to figure out how you're going to compensate this employee when they use EPSL, call counsel, look at the regulations. It's a complicated process, and just some due diligence on the front end will save you a lot of headache on the back end. All right, this is the good stuff. Let's get into the 6 reasons that EPSL is available. And as a reminder, before you get to any of these 6 reasons, it's only if an employee is unable to work or telework because of these reasons. The first 3 reasons, which are in black bold, those are the reasons that are subject to the higher daily and total caps. The latter 3 reasons, 2 in regular font and 1 in blue bold, are subject to the lower caps. And number 5 in blue bold font is the same reason that the EFMLA is available. So the first one is, an employee is eligible for EPSL if he is unable to work or telework because he's subject to a federal, state, or local quarantine or isolation order related to COVID-19. Well, what the heck is that? Well, I'll tell you. If an employee cannot work because, for example, he recently traveled, and we're talking about a Maryland employee, recently traveled to New York, and the governor has said that if you travel out of state, when you return to Maryland, you are subject to a 14-day self-quarantine. Okay, so you have to comply with that order, or you're supposed to at least. If that employee can't telework while complying with that order, meaning he'd have to come to the job site, well, that employee can't work or telework because of the order and would be eligible for leave. So it's the government order that must be the cause for why the employee cannot work. Number 2, an employee cannot work or telework because she's been advised by a healthcare provider to self-quarantine because of COVID-19. So simply that is a doctor, a nurse practitioner has told the employee that he or she needs to self-quarantine because of a diagnosis of COVID-19. That's what that one means. It's not a self-diagnosis. It must be from a healthcare provider. Experiencing symptoms of COVID-19, and this is important, and is seeking a medical diagnosis. So number 3, this leave is available if an employee is got the fever, can't smell, can't taste, the shortness of breath, the symptoms that the CDC has identified, and then that employee is seeking a medical diagnosis. Number 3 is available for the situation where I have symptoms and I'm trying to get an appointment with my physician to get tested. So for the period that I can't work because I'm waiting, I'm in the waiting room at the doctor's office or I'm at the emergency room trying to get a medical diagnosis, that's when this leave is covered. It's a smaller, more finite reason than you might think. But it actually makes sense because if I'm experiencing symptoms and seeking medical diagnosis, while I'm in the waiting room, that's going to be the period I can't work because of this reason. If I then get the diagnosis of a positive test, well, I'm going to be ordered to self-quarantine, and then we'd be shifting into reason number 2. But if it's, I received a medical, I'm experiencing symptoms, I've gone to the doctor, I'm waiting on the test, but otherwise I can telework, well, that employee is not going to be eligible for leave. Reason number 4 is when you have an employee who is caring for an individual who has been subject to or advised to quarantine or isolate. So how does that work? Well, first we have to look at individual. What does that mean? Well, that's got to be an individual who we would reasonably think our employee would care for if the individual is subject to a quarantine or isolation order. It could be a family member. It could be it could be a girlfriend or boyfriend, any of those things. But it's not if it's a neighbor who there's no basis for why the employee would care for that individual, then that employee is not going to be eligible for number 4, leave. I mentioned previously that the law has changed from its initial iteration to what was actually enacted. If you have guidance, the previous number 4 said family member instead of individual. So it's been broadened significantly, and it doesn't have to be a family member. So don't rely on stale guidance here. Reason number 5, this is the caring for the son or daughter whose school or place of care is closed. It tracks the EFMLA. Again, so this is going to be a reason where the public school, the private school, the daycare provider, or if we get into a summer camp who would normally be caring for the child when the employee needs leave. Well, if the employee's got to be able to care for the child, then this reason number 5 would apply. If another person is available to care for the child, then number 5 is not satisfied and the employee is not eligible for leave. If you have 2 parents or 1 parent and another adult caregiver in the household, well, one of those individuals is going to be able to care for the child or children, and the other one's going to be able to work. And they could share that responsibility, but bear that in mind as well. Another thing to keep in mind as well, can't some kids stay at home and not need constant monitoring? And the answer is yeah, and the government, the IRS, and the Department of Labor have considered this. And here's what you need to know for those purposes. Now, if someone is a 2nd grader or 4 years old, it's more likely that the employee is going to be unable to telework while they're caring for that child. If a child is over 14, according to the IRS, there needs to be special circumstances in order for an employer to be able to receive a tax credit for taking leave to care for a child over 14. The DOL doesn't have that criteria. But it is reasonable to say, look, I don't see why a senior in high school whose school is closed needs constant monitoring, and how is that preventing you from teleworking? There's some common sense in play here. Just bear that in mind as well. Number 6, nobody knows what number 6 is because it doesn't really have a definition yet. This is a catch-all that was included in case the COVID-19 situation expands into something we don't think it is, or we're just not yet aware of. And so in order for step number 6 to even be possible as a qualifying reason for leave, the employees, the Secretary of Health and Human Services is going to have to tell us what that is. So and that has not happened. So this should not be a reason anybody is using leave at this juncture. Employees can use leave intermittently, subject to some restrictions. If an employee is teleworking, intermittent leave is available. And that might be, I can work Monday, Wednesday, and Friday, but not Tuesday and Thursday because I'm sharing responsibilities or other for the child, for example. But if an employee is working at the normal location, intermittent leave is only available for the school childcare reason. And the rationale for this is that if you're taking leave for one of the other reasons, you're sick or you've been told to quarantine, we're trying to flatten the curve and stop the spread of this virus. So it makes sense that we want you to stay home on a continuous basis so that we're not further exacerbating the situation. But intermittent leave here is only available if you as the employer and the employee agree. And so keep that in mind. You've got to be willing to do that too. In most cases that it will make sense, but in some cases it may not. A lot of the questions I've been getting over the last couple of weeks is, well, what do we do with employees who want additional pay? Because this 2/3 pay is, we're missing a whole 1/3 of an employee's take-home pay. What do we do there? Well, here's where things stand now. The Department of Labor has put out conflicting guidance on this, but based on the statute of the text of the statute as well as the regulations, here's what you need to know. An employee always gets to decide whether they're going to use EPSL or other existing leave. If we're in a situation where we're talking about the first 2 weeks of emergency family and medical leave, the employee can elect, and you as the employer can require to use existing accrued leave. So one scenario would be, I'm using EFMLA, I'm also going to take emergency paid sick leave during those first 2 weeks. That's 2/3 pay. Then in addition to that, you can say you also have to take your existing PTO, or the employee can choose to do that up to 100% of their regular pay. The situation is different for the 10 weeks of paid EFMLA. And again, for those 10 weeks, the employee is going to be paid at 2/3 of their regular rate. The employer and employee can agree to supplement up to 100% of wages at that point. Keep in mind, if you are requiring or an employee chooses or you agree to supplement the 2/3 pay, you're not eligible for a tax credit for that additional 1/3. The tax credit is only available for the 2/3 or full pay as required by these 2 new laws. If the leave is foreseeable, which is typically with the school childcare reason, then an employee should provide leave as soon as possible. And then after the first time the employee uses leave, you can apply your existing policies for notice and reporting. So if it's a daily report, I'm still not coming in because I'm caring for my child, you can follow your normal procedures. But you can only require notice after the first time emergency paid sick leave is used if it's for any reason other than the school childcare reason. And we recommend that you accept verbal notice and then follow up regarding written notice so that you can have a documented paper trail about the reasons for leave and how long the employee expects to use leave. And the reason you should accept verbal notice is that's what the statute says. It says that verbal notice is acceptable, but it's a best practice to follow up and get that written documentation. We've created forms. The Department of Labor has not done so, but we've created forms that will allow you to document this information so that you can support your claim for tax credits. The reason, what you can obtain from employees is different based on the reason for leave. If it's reason 1 here, then you want to get the name of the government issuing the order. If it's reason 2, you're going to get the name of the healthcare provider. If it's reason 3, you're going to get the name of the healthcare provider. If it's reason 4, you're going to get the name of the individual and the relationship to your employee. You're also going to get the name of the healthcare provider or government that issued the order preventing that employee from working. And for reason 5, you're going to get the name of the school, the name of the children, and a certification from the employee that there's no suitable person who will be caring for the child or children during the leave period. Reason 6, again, we don't know how that's going to work in reality, so there's no documentation guidance for that. And you're always going to ask for the name, dates, qualifying reason, and a certification from the employee that they're unable to work or telework because of the qualifying reason. The forms we prepared spell this all out, so you're not asking for more information than the law requires, but you're getting what you need to insulate yourself and also claim the tax credit. If you've not already posted the notice from the Department of Labor on this law, you should do that. If you can't post it, you should put it on the internet. You can put it on your internet. You can email it out to employees. But since April 1, you're required to post or disseminate a notice, and you should do so. If you don't have it, shoot us an email. We'll get you the form. The DOL put it out, and don't want to get caught on some sort of technicality. And then you are required to maintain records under these laws for at least 4 years. I'm briefly going to highlight the small business exemption. If you are an employer with fewer than 50 employees, including religious and nonprofit organizations, you may be exempt from providing either the emergency paid sick leave or the emergency family and medical leave solely for the school child care closure reason. It's the only reason this exemption is available. And it's only available if providing the leave would jeopardize the viability of your business. Well, what does that mean? Well, it means that an authorized officer of your company needs to make a decision on a case-by-case basis. This is not, oh, we're a small employer. It's going to providing leave is going to jeopardize our business, so we're not going to provide the paid sick leave for the school child care closure reason. That's not what this is. As each employee comes to you seeking to take leave, you're going to assess whether that employee taking leave will jeopardize the viability of your business and then make a decision. So how will this work in practice? The first time an employee seeks to use leave because his child's school is closed, okay, that's one employee, we're going to provide the leave. But by the time the 20th employee comes, you might be on a more skeleton crew, you're not having enough individuals to do your workforce or meet production standards, and therefore you say, look, at this point, we got to deny the leave because of these reasons. So that's what that's talking about. And you're going to have to certify, just internally, keep your own paper records, that one of these 3 criteria is satisfied. And it's generally, there's going to be an impact on your revenues such that you're going to have to cease operating at even a minimal capacity, or there's going to be a substantial risk to the financial health of your organization because of this particular employee's specialized skills, knowledge, know-how. And then 3 gets to the example I talked about, where if you have insufficient workers who are able and available to do the job. It's intended to be a very narrow exception, but you should be mindful of it if you're going to be facing employees taking leave. This is not something you apply for. You make the decision in consultation with counsel that the exemption makes sense in a particular circumstance, and then you keep that documentation on record in case the DOL comes asking why you denied leave, or if an employee challenges why you denied leave. You don't have to affirmatively go to the United States Department of Labor and say, hey, I want an exemption here. That's not how it's going to work. As with most employment laws, you're not allowed, and of course we're not going to retaliate or discriminate against employees who take leave, try to take leave, make a complaint, or participate in a complaint regarding any of these leave provisions. Also know that layoffs and furloughs, if you've decided for layoffs and furloughs and other reductions in force, if you've decided that an employee cannot work or you have to reduce your headcount because you don't have the work available, that's not going to be a leave qualifying reason. That's a reason you've made, a decision you've made based on your circumstances, which is the reason the employee cannot work, rather than the 6 reasons we've talked about earlier. There's also very broad exemptions for healthcare providers and first responders. If you have employees who are healthcare providers, which is pretty much anybody you could possibly think of that could be called a healthcare provider, there is a broad exemption, and same thing with first responders. So if you think you might have employees in those categories, we should look at the definitions and again, consult with counsel. The tax credits that are available are 100% reimbursement for the paid leave. It's a dollar for dollar, also for Medicare taxes and even certain healthcare expenses. So it's off the top line when you're submitting your tax payments. It's something to be mindful of so that you're not feeling the full financial and economic impact of this leave. And with that, I'm going to turn it over to Eric as I've eaten into his time. Bear with me one second.
Hey, Garrett, before you...
Yeah.
Why don't you skip ahead and do the OSHA slide too, since you may have to jump off, and then we can
Sure.
roll back.
All right, bear with me. Okay. One of the things we're going to keep in mind now, as always, is workplace safety. The OSHA General Duty Clause continues to apply. You must furnish a place of care that is free from recognized hazards. Depending on your industry, there are going to be different PPE standards. The OSHA website does a really good job of laying out what your expectations are based on an industry by industry basis. I highly recommend it. It's very intuitive and lays things out very nicely, letting you know if it's masks, gloves, just good social distancing practices, or if you're a more high-risk workplace and therefore might need a respirator. So for our purposes today, just bear in mind that OSHA is a really good resource here.
Great. Thanks, Garrett. If you want to go back to the other one, I'll run it from here.
All right, did you get it?
I did, I believe. Let's see. Sorry about that. For some reason. Anything happening on your end, folks?
You can see your Zoom work. You might want to bring up the PowerPoint.
Yeah, I'm not sure how that all disappeared.
And Garrett, and Eric, if you want, you could put me into presenter mode and I could just forward the slides for you, Eric.
Sure,
Let's do that. All right, Janet, I'm throwing it over to you.
I may have it. It's back.
Oh, I just threw it over to Janet.
Okay, Janet, you take it from here. So we're at the employer obligation side. Okay, back. All righty, folks, sorry for that delay. So I know we're running a little behind on the time. Let me just hit a couple of the high points here. So one of the really important things to keep in mind is that you still have to comply with every other employment law that's in effect. And one in particular is the National Labor Relations Act, which many of you probably figure, why in the world do I care about that? I don't have a union. That law gives people what are called Section 7 rights. It's the right to band together and protest certain working conditions. So if you had a group of employees who said, look, we just don't want to come in today. We don't think y'all did a really good job of sanitizing after we had that COVID-19 positive employee come in. We're uncomfortable going in. Those folks would be protected by the National Labor Relations Act. By the same token, if they went out and wanted to make the public aware that you have an unsafe workplace, that you're not properly sanitizing, again, they may have the right to speak out about that and not be disciplined for that. So that's an important thing to keep in mind of the National Labor Relations Act. So next slide, Janet, wage and hour reminders. So under the laws we have that govern the payment of wages and overtime and whatnot, that has some bearing on if you start reducing hours of work for folks. Hourly employees just get paid for the hours they actually work. Salaried employees, if you start reducing their salary for partial week absences, for example, you reduce them from a 5-day week down to a 3-day week, you potentially could jeopardize their exempt status under the Fair Labor Standards Act and Maryland law and entitle them and all other folks in the same classifications to get overtime pay whenever they work over 40 hours in a week. So be careful about docking salaries. We've got some more detailed guidance on this on our website, which you can look up. We've got a whole COVID-19 section on there, and you can get some more detailed guidance on that. Hazard pay, it's become a hot topic, especially for folks like in the with the Amazon, Whole Foods, public sector folks, first responders. You don't have to pay hazard pay. A lot of employers are starting to do it. I even have a liquor distributor client that's doing it. Those folks are in the warehouses packing your cases full of wine. They're getting an extra $2 to $4 an hour for doing that right now. If you do that, it becomes part of the regular rate of pay. It means you have to add that to the overtime calculations and pay overtime, and by including that hazard pay in the calculation. Next slide, please. So in the event you are going to be conducting any workforce reductions, there is a federal law called the WARN, Worker Adjustment Retraining Notification Act, which applies only if you have 100 or more employees and requires that you give 60 days advance notice in the event you are shutting down completely, or if you are laying off and it's going to be more than 50 persons losing their jobs in the layoff, and it amounts to at least 1/3 of the employees at that particular worksite location. Maryland has its own new miniature WARN Act, which fortunately won't take effect till October the 1st. And we're hopeful Governor Hogan may veto that, but flag that for the fall. If it does not get vetoed by the governor, we're going to have even more stringent obligations in the great state of Maryland to give advance notice to employees of layoffs. One question I get a lot is furloughs. Can I furlough people instead of lay them off? Functionally, there is no real distinction between the two. However, in practice, here's what happens. Folks tend to think of furloughs as temporary in nature versus permanent. Layoff being a permanent elimination of your job. Furlough is thought of as, look, it's going to last for 30, 60, 90 days or so. Maybe we'll keep your benefits in place and otherwise not pay you and then bring you back at the end of this furlough period. If you do that, folks can still qualify for unemployment, which I'll talk about in a moment, and get their benefits. So a lot of my clients and Garrett's clients are going to this furlough option now in the hope that when the economy reopens to some degree, they can bring folks back to work. In the meantime, they get their unemployment. Next slide, please. OSHA we covered, so we can skip on to the slide after that. EEOC has issued some guidance allowing us to take a little more liberties in medical inquiries than we otherwise could do before the COVID-19 crisis arose. Traditionally, EEOC took a real hardline stance. You couldn't ask people about health conditions, couldn't inquire what the diagnosis was from their doctor. Now you can do that solely in the context of COVID-19 related inquiries. You can ask if they've tested positive. You can ask if they've traveled to a high-risk area like New York City or China. You can ask if they're experiencing symptoms like fever, chills, etc. You can take their temperature when they come in to work in the morning. All of that is permissible solely for the COVID-19 related inquiries, you can't ask about other types of health problems. Those remain impermissible under the EEOC's guidance. Next slide, please. Okay, the CARES Act has the CARES Act is a separate law from what Garrett has been talking about. This was signed about 2 weeks ago by the president, and it is most pertinent here for a couple reasons. One is it dramatically expanded unemployment benefits, and it adds an additional $600 per week on top of whatever the maximum state benefit already is. So in Maryland, for example, the most you can get is $440, I believe, a week under current unemployment insurance. Now you can get an additional $600. So if you would have qualified for the max under Maryland law, you could now get up to $1,040 per week in UI benefits. So it's $600 more on top of whatever you would have previously qualified for. So if you were on the high end there, you could potentially make over $1,000 a week in UI. This is why a lot of clients have taken the furlough option. They've realized rather than reduce pay, for example, or reduce hours, it might make sense just to furlough people, let them go out and get their $1,000 a week or so in UI, and then bring them back when business picks up again later down the line. Briefly, they've also extended this for the first time ever in history to self-employed persons. Independent contractors are now eligible for UI. I will tell you from personal experience, because my wife's a massage therapist who has her own business which is shut down. They have no mechanism in place to process these claims right now for the self-employed. So although you're eligible, it's going to be a long process before they're going to be able to get those benefits. They're working on that. They eventually will be eligible. Next slide, please, Janet. And finally, before we get to the questions, the Paycheck Protection Program, PPPs. This is the one you probably heard yesterday. The federal government ran out of money, $350 billion that was used up in the course of a couple weeks. Hopefully there's going to be a supplemental program. It's a very, very generous small business loan program that provides for loan forgiveness. The amount of the loan that you can get equates to the equivalent of 2.5 times your monthly payroll, the mortgage, rent, utility payments you would pay over that period of time. So you get all of that is the max you can get. It's an interest rate of 0.5%. It's repayable over 2 years. And actually, I'm sorry, their interest rate is 1%. And the most important part of that is that it is partially forgivable. The amount that you spend on payroll, utilities, rent over the 8-week period after you get the money is forgivable so long as you don't lay people off and you don't cut salaries more than 25%. If you do lay people off, so long as you bring them back to work and restore your workforce to the February 15 level, then you get forgiveness of that amount. So it's a very, very lucrative program. I have had clients use this as a lifeline. Again, the money is out right now, but there's supposed to be supplemental appropriations coming out of Congress eventually. So just keep your ears tuned for that if you think you may be eligible. So with that, I think we've got a couple minutes for questions if there are any. If Janet, Michelle, you want to fire away?
Sure, yeah. So first, thank you, Eric and Garrett. Again, we mentioned lots of good information. I just want to quickly reiterate that this presentation will be made available, as will the recording. But there are a couple of questions. So Eric, some of these you may have touched on, but just looking at some of the questions as they have been submitted. So the first is from Laura, and the question is, would an employee whose parents watch their child and who are currently unwilling to watch the child because they're trying to social distance qualify for EFMLA?
Yes, again, if that employee is able to certify that there's no other person who is able to care for their child or watch their child due to the closure of the child's school or daycare, then the answer is yes. I think the parent's unwillingness to be near the child because of social distancing reasons would qualify as a legitimate reason to say there's nobody else who's presently qualified to care for my child.
Okay, great. Eric, we had someone very similar to your wife who's also a licensed massage therapist, and as you pointed out, they have not been able to apply for relief. So the second part to that question is they also have a part-time 10-hour-a-week position and they were laid off from that due to the current situation. The question is, how does that affect how this individual would file for subcontractor relief?
Yeah, so again, for the 10-hour-a-week position, if they were a W-2 employee, that individual could apply for unemployment insurance benefits to collect on that. It wouldn't be a terribly generous benefit. Separate from that, they can apply for the shutdown of the massage therapy practice. Again, speaking from firsthand experience, I've read some articles on this. The Department of Labor needs to get more software out to the states to enable them to process these claims for the self-employed and the gig workers. These people have never before been eligible, so that the infrastructure is just not there to process those claims, but they assure us it will be there. Something else to keep in mind also for someone who's self-employed is the PPP loans. Again, if Congress refunds those, you can, even as a self-employed person, you are able to apply for one of those small business loans, which will be forgiven. You would go through all the same math, but you could get relief that way as well.
Great. So Eric, do we have time for just another quick question?
We sure do, yep.
Okay, all right, so another question here. Can an employee request EFMLA and EPSL, the reason number 5, at the same time?
Yep, so what would happen then would be, again, reason number 5 is the child care, school closure type of situation. Employee would have to show they're unable to work or telework. Assuming they meet those criteria, then for the first 10 days of that leave where they're out, they can use their EPSL leave and get their pay for up to 2/3 of their pay for the first 10 days. And then once those 10 days are done, they can roll on to the EFMLA leave and take that for up to 12 weeks. One variable here, which I'll throw in the mix now because it's an important one, because now that we're getting to that point, is on the EFMLA, it only remains as a qualifying reason number 5, so long as the school year is in session. So I'm going to just make up a date here. Let's say your school year is supposed to end on June 15. The employee cannot keep taking EFMLA leave after June 15 unless they can show the child otherwise was going to be like in a camp or a daycare program that summer, and now that camp or daycare program is also shut down. So then they can keep on leaving. But if the plan was just to have the child finish school on June 15 and come home, then and then hang around the house, you are no longer eligible as an employee to keep taking FMLA leave after the end of the school year. So I had a long talk about this issue with the client yesterday because, you think about it, it's only 2 months from now before we would get to what would otherwise have been the end of the school year.
Great, wonderful. All right, I am looking at the clock and I want to be respectful of everyone's time. I apologize. There are many wonderful questions, and as mentioned, both Eric and Garrett have agreed to take a look at these questions and we will provide answers to you. So for those of you who submitted questions and didn't get an answer, be patient. We promise we'll follow up with that information. And again, I want to thank everyone on behalf of our entire team. Eric and Garrett, thank you both very much for your time and expertise. Complex stuff. So we appreciate the expertise that you're sharing. And to all of the people who've registered, thank you very much for your time and attention, and stay well.
Great. Thank you, Janet.
Take care now.
Bye-bye.